The Caribbean Court of Justice is set to rule on Wednesday whether it has jurisdiction to overturn the June 22 decision of Guyana's Court of Appeal, which gave orders to the Guyana Elections Commission to consider only valid votes to determine the results of the March 2 polls. Alexis Rodney tells us more.
A week after listening to submissions in the Ali Jagdeo versus Eslyn David and others application, the CCJ will hand down its decision. Analysts both in the legal and political fields are hard-pressed that an assumption of jurisdiction by the CCJ will have irreparable constitutional and political consequences. Guyana's position remains that the CCJ cannot intervene in the matter. Attorney General Senior Counsel Basil Williams has been steadfast in the binding power of Article 177(4) of the Constitution and the Caribbean Court of Justice Act Chapter 307, which prohibits any further appeal of any decisions handed down by Guyana's Court of Appeal. On Monday, June 22nd, Justices Brassington Reynolds and Don Gregory both ruled that the appeal court had jurisdiction to hear a matter filed by private citizen Eslyn David, prohibiting the Guyana Elections Commission from making a declaration of the election's results using votes found to be fraudulent. The BPP has now approached the CCJ with the knowledge that the Caribbean Court has no jurisdiction to ask that the appeals court's decision be struck down. In his submission last Wednesday, Attorney Reginald Armour cautioned the 5-panel judges to not overstep the edict of Guyana's Constitution and the CCJ Act.
Your lordships must be very slow, very deliberate, and very careful to approach this case carefully within the context of the Constitution and your treaty to determine the correct legal interpretation to be given to your treaty in relation to jurisdiction and to 177 in relation to the section under which the Court of Appeal, we say, correctly found as they did.
Armour's argument has been the talking point of every legal mind that has perused the application. Lawyers within and outside of Guyana have argued that Guyana's constitution is pellucid and should not be disrespected by any outside interference. Senior Counsel Armour closed his arguments last Wednesday, reminding the court of the words of its very own judge, Justice Winston Anderson.
His Honor, Mr. Justice Winston Anderson, one of your brothers, Millard, has actually spoken extrajudicially on this very subject, and we put that in our tab 3. He gave a speech at the Norman Manley Law School back in 2013, I believe it was, and he recognized in that speech the limitations of the Caribbean Court of Justice in relation to Section 177(4). He recognized it as an impediment to the jurisdiction of this case, of this court's jurisdiction, and he expressed the wish that that situation could be improved, but he nevertheless recognized that any sound lawyer, and as any good judge must, and I quote him, there is little, if anything, that the CCJ can do, in effect, end of quote, can do, in effect, to change the Constitution of Guyana.
Armour said, as hard as it may be for the judges to recognize it, the court is legally constrained in this regard. For InfoHub, Alexis Rodney.